Computer. Hello and welcome. Today we're going to be talking about collaboration being key when working with law enforcement in our intimate partner violence cases. As you know, we are AEquitas and we are federally funded to provide prosecutors and allied professionals with really hopefully innovative, informed, and most likely, hopefully, practical information that you can take away and implement in your work, tomorrow in the courtroom. We do that in a lot of ways, including training events, webinars, published resources, most of which are all public facing on our website. We also provide one-on-one consultations to prosecutors who maybe want to use us to soundboard or do some case-specific research. We're also involved in many partnerships and initiatives around the country, working on things like the Sexual Assault Kit Initiative and the Human Trafficking Enhanced Collaborative Model task forces. You can follow us on any number of our social media platforms. We're always pushing out new resources, new training opportunities, and we welcome you to check those out along with our website. Our support for this project is awarded by the Office on Violence Against Women, the U.S. Department of Justice. And while our work is informed by them, our opinions, findings, and conclusions and recommendations are not necessarily those of the Department of Justice. In our effort to provide you with the most up-to-date information, we're often sharing information and research and studies that were developed by others, and we do that under the fair use edict. So today, as we talk to my colleague, Jonathan Kurland, John, welcome. We want to thanks. We want to make sure what we're discussing is where are these opportunities that we have in our work, no matter where you are in your office, to enhance how you collaborate with law enforcement. And one of the benefits of this enhanced, collaboration, hopefully, is to build better cases and cases that are evidence-based, and perhaps even have the opportunity to prosecute those cases without a victim who's able to participate. And of course, while we do that, we always want to be ever thinking about our discovery and due process requirements. So I want to get started, John. I know you are a prosecutor in Berks County, Pennsylvania. Can you tell us a little bit about what your practice entailed there?
Sure. Thanks, Jane. And thank you for inviting me to join this conversation today. I was a prosecutor in Berks County for about 16 years. And for those not familiar, Berks County, Pennsylvania, we're known for the city of Reading. And my joke is not only known for the city of Reading, but the best snack pretzels in the world. But it's a really interesting environment and jurisdiction in which to be a prosecutor, because the city of Reading itself, very urban, surrounded by a lot of suburban and communities. And then after that, it's surrounded by some really rural communities, including a lot of Amish and Mennonite communities as well. So there was a lot of variety and diversity within Berks County in which to experience cases and see some of the distinctions, as well as a lot of the commonalities between these different kinds of cases. But worked there for 16 years. Primarily focused on intimate partner violence cases, both homicide and assault, sexual violence cases, and child abuse and prosecutions and things of that nature.
Right. So we often sort of hear this phrase of being victim-centered or a victim-centered approach. What does that mean to you and how you practice?
Sure. I think the graphic is pretty helpful because it's the idea. I think at its ultimate level, a victim-centered approach is that what it entails is, rather than having the victim adapt themselves to our system, is that we look for ways to adapt our services, our system, whether we're prosecutor, whether law enforcement, or one of the other kinds of disciplines represented here in this graphic. We look for a way to adapt ourselves to the victim, to meet the victim where they are, rather than have expectations that the victim has to adapt themselves to be able to participate in the criminal justice process and report their crime. Because the challenge of these cases, well, they are evident to anyone whose practices in this area. They're no less so for these victims. Victims who are caught up in a cycle of dependency and power and control, who are manipulated by offenders, who have vulnerabilities that are developed and then exploited by offenders over a cycle of violence. As tough as these cases are, they're tougher for the victims. And the kinds of challenges victims have, those are the same challenges that are going to make it harder for them to participate in an investigation, participate in a prosecution, to communicate what happened to them, to have the support necessary to really go through something that's going to be challenging for their life. So a victim-centered approach is going to be one, recognizing these kinds of challenges victims have and doing our best that we can as prosecutors and working with other allied professionals to try and ameliorate it as much as possible. What can that mean? It can mean that when victims bring challenges, such as they don't want to talk to us, or maybe they're even being argumentative or adversarial with us, not taking that personally, not looking at victims as challenges in our case, as the problem in the case, such as when there's recantation or minimization, but looking for a way to understand maybe what's causing some of those challenges for the victims, have some empathy for that, and still looking for a way to try to bring justice in the case. And justice on one level, I don't want to minimize accountability for the offender, but it's also trying to recognize the needs of the victim, the safety of the victim, and the privacy of the victim. As often as we can, reconciling that with accountability for the offender and this very real public safety concerns that offenders represent, but also not having offender accountability obscure what the needs and the primacy of the victim is in our case and in our prosecution. Simpler way, and I know I was sort of talky and wordy on it, it's going to be understanding victims are more than just talking exhibits.
Oh, I love that. And I always think about it as trying to recognize that, that file in front of me as the prosecutor, that seems to be my focus, is this case, this trial, and how many ripple effects the situation has had for a victim's life. And that beyond even our comprehension is just constantly trying to be humble about what it means to be a victim that's just thrown into this system, and anything we can do to adapt our practices. I love how you said that, adapt our practices to serve them instead of the other way around.
And I always think of what it is we're asking victims to do in these cases. I mean, one, just being dropped in the middle of a case, this is something that as a line prosecutor, we might understand on an almost reflexive level. Maybe we have all the acronyms down pat. But I bet you when we were baby prosecutors, we felt like we were in a world that we couldn't understand. And that's with benefits of a law degree and mentors and everything like that. Similar to what we do to jurors, we're doing victims who are often in a harrowing and traumatizing situation and just dropping them in the situation, asking for their participation with results that a victim doesn't necessarily know that they can trust or rely on, and is going to uproot the life that they know. And maybe from our satellite view, we think, oh, well, rationally, why wouldn't a victim want to do this? But in a lot of ways, we're asking a victim to do this blind as to what's going to happen and what's going to happen to their family, to the offender who they have personal feelings for and affection for. And often when most victims aren't going to have a really big support network.
So we're talking about some of those barriers and ways that we can minimize those in another part of this series. So I want us to focus on how the collaboration can be a strategy to minimize some of those barriers and to achieve that offender accountability or justice, however we define it. How can collaboration really help us with this approach?
Well, I think we have a good synopsis right here with each of these points about supporting victims, improving or demonstrating system response, building stronger cases, and achieving justice, and I'm not going to put that in quote marks. I'm just going to accept that justice has a broad implication about what it might mean, and it might be individualized to what's going on in a particular case, given the victim and their context, as well as the offender we're dealing with. We're not just analyzing it through one lens, but through multiple lenses. But look, we talked about in the beginning, or I talked about in the beginning too, and you know too from your practice, and folks listening to this know from their practice, these are tough cases. And I think trying to do it alone through just one disciplinary exercise, whether as a prosecutor or as a community advocate or as a law enforcement investigator or responder, you're going to be making it more difficult. And ultimately, by collaborating with partners, and hopefully we're going to have conversations about ways, and hopefully concrete ways we can do that, by collaborating with other partners in the system, it's almost going to be like a force multiplier. And we're going to be able to build off one another's expertise that we each have in our discipline to look for ways to build better investigations, better supports for victims, and better prosecutions. And by working with one another and not, and I know the common term is siloing ourselves from our other disciplinary partners, but by collaborating with one another, it's going to build support for victims. And that's the empathetic and nice thing to do. And that's great. And you want to help victims just to be a decent person. But supported victims, while it's not the goal necessarily of a victim-centered approach, supported victims are more often, you're going to better be able to facilitate them being able to participate in the system. So even if maybe you're just being get the bad guy, ultimately the victim-centered approach is going to be the approach that's going to ultimately be more successful for that goal. Because supported victims and looking at them as integral parts of our prosecution is something more than talking exhibits, is going to give victims an opportunity to better participate in investigations and prosecutions. And while we certainly can and often should look for ways to prosecute offenders even without victim participation, if we have victim participation, I think it's less challenging. And that's something that we always want to endeavor to do. The other thing is, with this collaborative approach, we get stronger cases. And sure, we get stronger cases by in one sense, collaborating with law enforcement. We get, as prosecutors, to understand law enforcement limitations better, what their capacity is, what their concerns are about cases, adapt and adjust our expectations. But as prosecutors, by collaborating with law enforcement, hopefully we get to start getting them to think of some of the expectations and challenges we have as prosecutors, and some of the tools that can help bring us accountability at trial and more accountability to offenders as well. And also too, just with broadly speaking, demonstrating the system response or improving system response, working with our other by law enforcement and other disciplinary partners, it's just going to make things more efficient and help us direct systems to victims or responses to victims more particularly and more specifically, and then on a more individualized level, which is, in the beginning, I talked a little bit about figuring out ways to adapt ourselves to the victim. This collaborative approach is what's going to allow us to do that, because by having different partners who interact with the victim, we learn more about what that individual victim needs, rather than telling the victim what we're expecting them to do. Mm-hmm. And I mean, I think it's sort of achieving justice. Wow, you get better supported victims, more respected victims with more autonomy, and a greater likelihood of offenders being held accountable. Justice can have lots of different meanings, but I think in most instances, you're going to get a lot closer to that goal with this approach than you would by going it alone or unilateral or narrower perspectives.
Yeah, I agree with you. And I'm just trying to think back when I was that so-called baby prosecutor. I started my practice in Miami-Dade County, and we were maybe a little bit bigger than Berks. And you started in
a lot bigger.
One of the ways you could start in the office was your first assignment would be in our misdemeanor domestic violence unit. And there were typically about 25 dedicated prosecutors in that unit. And that's how I started my career. And all I did was misdemeanor domestic violence for the first year. And I wouldn't have necessarily thought that I could change any systematic response, right? Like these were already in place. This was the procedures. This is what you did. And so I guess I'm looking for some ideas of, yes, we want to do this sort of systematic, make sure that we're not in silos and that we're working together. But for a prosecutor that maybe doesn't have decision-making ability within their office on that level, what can collaboration look like on just that really sort of entry level case by case basis?
Yeah, that's true. When you feel lucky enough to get a job, usually fresh out of law school, and you're working in that, you more often feel like figuring out how do I respond to the system rather than how you can help shape or impact the system. And certainly when we talk about systemic ways to build collaboration in a system, I'm not trying to minimize that by any stretch with these thoughts. But really, I think where a lot of this collaboration starts to happen and where you start to personalize it and practice it, it's going to be on that individual case level. You, the individual prosecutor, working with your individual officer, maybe being connected with the individual community advocate who has a connection with this victim who you're trying to get justice for. And what that collaboration looks like on that level, I think on one level, it's building relationships with those partners and building relationships that are going to be a foundation, not just in that initial case, but over a series of individual cases, and get a better understanding about how you can each complement one another, or how your strengths can complement one another, how the community advocate can help you maybe understand what support or challenges the victim's having, help you as a prosecutor, maybe helping the law enforcement officer understand investigative opportunities that are out there to not only help this victim, but to help get the offender. By helping to look for the past incidents of abuse that are almost always going to be there in any sort of domestic violence dynamic where there's a cycle, figuring out ways that maybe you can charge a stalking charge and talking to the officer about doing that, about developing ways to maintain contact with the victim that are something beyond like, what's the number to your burner phone, but gee, tell us who are family members that you always connect with no matter what happens? What are some social media? How can we keep you informed? Meeting with the victim more than just in the context of when a hearing's coming up, but looking to meet with the victim on as much as you can on a regular basis, and involving law enforcement and the community advocate in those conversations with the victim. And I know these are a lot of resources and a lot of effort to do. And I think the really holistic, victim-centered, offender-focused type approaches, they do take a lot of prep and a lot of effort. And sometimes because resources are limited, time is finite, to identify which domestic violence case or intimate partner violence case you can devote the full scope of resources to, the kitchen sink to. Maybe law enforcement and community advocates, that's a great resource to help triage which cases you want to do it. Like when the officer tells you there's a lot of history of violence, it's more than just this incident I responded to. When the community advocate is telling you, hey, look, this person doesn't have any support. They're worried about being deported, or they don't have any family, helping that to identify, well, gee, this is a case where I really need to be connecting with the victim more than when another hearing is scheduled.
Yeah, I would always ask officers, like what's not in your report, because there's certain things that you can't, or folks have trouble like articulating in the four corners of a report. And officers would always have such great insight. They'd be like, this guy, my spidey sense has gone up, almost like that. And that would help me triage. Like, this guy was on the scene in front of me, continuing to threaten his wife. And then it would be like, okay, let's maybe this is the case, like you said, the kitchen sink, or I'm going to pay a little special attention to this. And I thought law enforcement officers always had really wonderful insight into that as we went forward.
And if I can add to that, Jane, too, because as you were talking, it sort of struck my mind too. Ideally, every prosecutor is in whole hog, every law enforcement officer is in whole hog, and every community advocate is 100% devoted. My experience, and I imagine the experience of folks listening to this, sometimes folks have different motivations. And I know that's true for prosecutors, for defense attorneys, and for some law enforcement officers too, like what motivates them to do something in a case. But by building that relationship with an officer and trying to understand that officer as an individual, you'd maybe get better insight into what motivates them. And so, and then when you need that follow-up or you need that extra rapport building with the victim, you have a better idea about what might incentivize that individual officer than just being the kind of imperious prosecutor that's going to be ignored and giggled at behind the scenes.
Yeah, because we often have follow-up requests, right? I think we'll go through some of that. And if we're asking them, hey, could you follow up on this, or could you do more investigation? The best way to do that is to really actively involve them and talk through them, like why in this case you're asking for that. Like, hey, I pulled an old report and it showed signs of strangulation, so I'm really concerned about this. I want to see what else we can find out about his history. Can you go look for X, Y, and Z, instead of just go look for X, Y, and Z for me?
Yeah, well, that's it. I think that's the key to so much of what we're doing. And I think even just like with the victim-centered approach, as much as you can, you want transparency with victims. There's no secret sauce. That's not the kind of business we should be in as prosecutors. We're not a fast food restaurant with our secret recipe. I think the same is true with our disciplinary partners, our cops too. Like, hey, look, I want you to follow up on this, not because I know you're stretched thin and you don't have resources, but because, hey, this is going to allow us to really hold this guy accountable, or this might motivate a negotiated resolution or something like that, or this might keep the victim safe. And also sometimes you have officers that are go get them too, and it's the worry is I have to hold them back. Other times, sometimes it's motivating officers, but by appreciating each person as an individual, I think you're going to get better results.
Yeah. You also sort of identify champions, and depending on the size of your jurisdiction, I even in a large jurisdiction like Miami, I definitely had, I don't want to say my favorite, but I knew the officers that I could go back to and ask, hey, I've got some extra legwork, do you think you could help me out? And then those were my champions. And then I could almost even like pair them with other folks and help like spread the word. But I think it is also important, especially when I first started, I didn't quite, you don't learn these things in law school. You don't learn how a case definitely goes through your office or your courthouse or your courtroom. And so I think it's important to sit down and kind of map, like how did we get from 911 call or initial report to trial? Like what are all those steps? So Florida's kind of unique in the fact that we do pre-file interviews. Every prosecutor does a pre-file interview with the lead officer and the victim and any other key witnesses. And then we make a filing decision and file by information. And then we prepare for trial. So that looks a little bit different, maybe in jurisdictions. I'm sure that's not how it worked with you, Jon. Sure. Like, did you go through an adversarial preliminary hearing or?
The Pennsylvania, they did use adversarial preliminary hearings. Grand jury is not a common mechanism. And actually for most of my career, you couldn't even use indictments with a grand jury. But usually what the instance would be is police would respond to an incident. They would have a criminal complaint, which they would be filed, and that would have an accompanying affidavit of probable cause as to whatever charges they charged. And then there would be a preliminary hearing that's scheduled within roughly a week. And officially, these would only have to be prima facie probable cause type proceedings. Reality is, though, and many times they would turn into almost mini trials. And because and sometimes it would also be an opportunity when negotiated resolutions would happen, because you have everyone there. You'd have your defendant there, your defendant's lawyer, the victim would be there, prosecutor would be there, cop would be there. So it'd be a great opportunity to get everyone's feedback. And so sometimes negotiations could be resolved. Other times there'd be a hearing where, depending on the minor judiciary overseeing it, it would be very contained or very expansive. And sometimes as a prosecutor, you'd be okay with it being expansive, only to give the defendant an idea of the scope of evidence against them and help them decide how to manage things better on, or help the defense attorney persuade the defendant what to do later on. But that's a lot of it, I think, too, like this sort of mapping how a case happens. As you described in Florida, yeah, there's a formal process. I mean, you can look in your local procedural rules or your state procedural rules, and for any jurisdiction, and figure out how a case happens. But there's also some organic, I think, shapings of it that happen from jurisdiction to jurisdiction, community to community, and I would dare say court by court. That are going to impact things that are really so informal that you really only get an appreciation of practice for. But mapping it out in your head and in combining both the formal component and informal component in a manner where, one, you want to be able to explain to victims in manners which they can understand and then be able to give you informed input, but then identifying ways you can talk to officers. Ideally, what's going to be happening, though, too, is you build relationships. Hopefully you're going to have, like the champions you talked about, officers that might touch base with you, even if you're not the on-call person, and ask for your input about a case when there's a charging decision and what to do, or to get you involved maybe on the ground floor. And if that's appropriate with your office organization as well. But yeah, I think because there's so much, there's some informal sort of wiggling that comes into how these cases are resolving out. Your ability to develop relationships with the people in the system is going to help develop points where you're going to be figuring out where to collaborate and support law enforcement, and where they can rely on you too, and you can get their support.
Yeah, and I think in DV cases, IPV cases, so much of our efforts are geared towards, are we supporting the victim? Do we have a victim that's able to participate, making sure the victim is aware of the proceedings and going to trial? And obviously all of that is what we need to do. But I find that sometimes then we just sort of put the law enforcement on automatic, and we're like, oh, they're professional witnesses. I don't need to actually spend very much time with them. I don't need to explain what's going on. They kind of get it. And I can better spend all of my time and energy over here. And I think that's a misstep and a missed opportunity.
Well, it's teamwork. Ultimately, I think it's the best model, and each of you should be complementing one another. I mean, it's something I would always talk about with officers whenever they'd feel bad about calling me. And it's like, because I would encourage them to call me early and often in the case. And I would always try to say, don't worry about it, because look, if this goes to trial, I'm going to be bothering you a lot and taking out a lot of your time for the 2-3 weeks, month, if it's a big case, the months before a trial, begging your time, meeting with witness prep and all this other thing. So you shouldn't feel guilty at all about calling on me now, because at the tail end of the case, I'm going to be doing that with you, and if there's a trial. And so it should be reciprocal in that sense. And I think that I think it's best just to sort of check our judgment too, like sound off with officers about, hey, this is what I'm thinking about for the case. This is what I'd like to develop. This is, can we do this investigatively? This is what I'd like to pursue. This is what I'm thinking about for trial, for witness order, and this is my reason for doing that. Does that sound nutso to you?
The official legal term, nutso.
Yeah, exactly. Well, I mean, again, yeah, nutso isn't the terminology we learned in trial ad, is it? But
yeah, so I want to go through some examples, and obviously this isn't going to be, relevant to everybody because it looks different places. But here's some examples that I came up with.
Mhm.
I thought maybe we could flesh them out together of those possible intersections, and some more formal and some, like you said, those informal opportunities where oftentimes that's where that relationship building really happens. So on-call prosecutors, we had on-call prosecutors sort of, but it was like only really for more serious cases like homicide, robbery. And then we had an on-call prosecutor that was like a generalist. And they could get calls from anything. And I thought to myself, gosh, we should really have like and maybe there is now, I actually don't want to speak to this because I've been out of the office for a long time, but like a misdemeanor domestic violence on-call prosecutor. That would be really a great way to build that collaboration from the very start.
Right. I think on-call prosecutions responsibilities. I know sometimes in the beginning, it's often exciting. I know, especially for a fresh young prosecutor. Hey, look, I'm taking calls after hours. This is how relied I'm on. Later on, it can be sort of not as looked forward to. I'll say diplomatically.
We had a
But
pager.
I remember I had the pager in the early 2000s.
This was 2014.
Oh yeah, no, yeah. Berks County, I think, was a little bit better provided for than Dade County then. I remember the pager in 2003, and then I remember the Blackberries up until 2009. And when we got iPhones, I forget when, that was like the most exciting thing. And it's like, oh wow, look at me, and what could be better than a county employee job? But yeah, so being on calls, I know it's not as often later in career cycles as looked forward to, but it really is an opportunity because it's your opportunity to build that relationship with the police officers and think about opportunities to develop a case that maybe like a newer first responding patrol officer might not always think of. I'm going to go back to stalking examples too, because a lot of times when you get the case at the preliminary hearing or when you're doing depositions or something like that, and you think of all these charging opportunities that might not be as optimal than if they were pursued at that initial response. On-call gives you the opportunity to do that, to think about those other angles and to work creatively with that police officer. So that maybe something that is just facially presenting to the officer as a misdemeanor assault, you do some digging and it's like, wow, this is really actually more serious felony stalking. This is actually a strangulation case. This is an intimate partner sexual assault. Maybe these are the angles we want to do to pursue it. Or hey, look, so we don't have to do the evidence-based prosecution. Maybe let's think of ways now we can sort of figure out ways that we can do this if the victim isn't able to participate later on, or maybe even set some foundation so we facilitate the victim being able to participate and not losing that victim through attrition later on. Finding out about history of drop charges or intimidation, things like that. And on-call is a great opportunity to do that. I kind of think though, if you're having a good career as a prosecutor, and if it's allowed by the custom of your office and jurisdiction, cops are going to be calling you whether you're on call or not.
That's true. And it's a great opportunity to do some educating. I think probably one of the most common calls we got was from officers that were struggling with a predominant aggressor analysis. And they didn't know who to arrest, or they wanted to arrest both people, and they knew enough to call somebody. And so I would say that two things. One is it's a great opportunity, some education, and it should be, I always really encouraged it because it's so much easier. I don't want to have to untangle that before because there's so many collateral consequences, even if, you're arrested and no charges are ever brought, like just that arrest is really damaging. And we can talk about that another day. But I also would say that I think it is important and something to consider within your office if there are specialized domestic violence on-call folks. So because there is, not everyone's practice, are they familiar with some of the more complex dynamics that we see in domestic violence, and some of those not necessarily immediately You know, like these behaviors that are probably responses to trauma, they can be misconstrued as something else. So those would be my two takeaways on the on-call prosecutor piece.
Not to go off on a predominant aggressor tangent, but when you got that predominant aggressor question when you were on call from an officer, you ever get how liberated did that officer feel when you asked them, well, who do you find more credible? Like they didn't know they could do that. And when you talk to them about it, it's like, oh, wow, that I, the officer, can do that. It's
yeah. Yep. So this would be like more of a formal participation, but even if you're not actively involved in it, it'd be good to know, are there task force? Is there a task force? Is there a multidisciplinary team that's meeting on some amount of regularity for specifically domestic violence or whatnot? I'm not sure. I never was at the point where I was really involved in this, but I knew that they occurred and I occasionally went to meetings, but I feel like it was something that we could have integrated a little bit better into our practice.
It's something I wish I would have gotten involved with earlier in my career. And I got to tell you, I mean, of course, there are exceptions in some offices, but even if you're a greener prosecutor in your office, I don't think you'll hurt yourself by asking your supervisor, you know, if my other duties permit, can I attend one of these multidisciplinary meetings just to see what happens? You're not going to get in trouble for doing that. I don't want to speak universally. I'm sure in most occasions you won't get in trouble for doing that. And even if you're not there to talk about anything, just again, getting that opportunity to build relationships with people. I often think like, look, the policies you talk about at multidisciplinary team meetings, what you learn about individual cases is great, but just getting to know people so that when you make that 3 a.m. call to someone from the women's shelter or that third shift police officer, you're not starting a relationship from zero. You know that person on a first name basis from having seen them at this monthly, weekly, multidisciplinary meeting. And those are where the dividends from these meetings really happen, with folks getting to know one another as people, not just different disciplines and agencies.
Yep. So pre-file interviews, this was something that we engaged in, and our practice was really robust in this regard, as we always spoke to someone between arrest and filing of an information. And what I learned through my practice was, you know, we have to have sworn testimony to establish the charge, right? Establish the elements. And then to learn later on, and as I got more comfortable, taking that opportunity to really start the collaborating there, and start talking to the officer as if they are a partner, and not just like, what did you see next? What happened then? What were the statements? It was more like, what do you think about this case? You know, or I'll tell them maybe something that I've learned about the case since they last touched it. And so we're starting to build like a team effort. And that might be also an opportunity for me to say, you know, what would be great is if we also were able to pull these phone records to collaborate this, or after talking to the victim, I think we might be able to establish a stalking charge as well as this battery charge. But what I might need from you is X, Y, and Z. And that really was an opportunity for that early on in the case. So I don't know if that's part of, you know, it's not everyone's practice or it's not everyone's policy, but like, is there an opportunity for that?
Well, Jane, and not to turn you into the interviewee, but the pre-file interviews, they were with the arresting officer or the investigating officer, whatever the correct term would be. And that's where you're like setting out the outline of a case and something that would be a narrative of what's the basis of the charges. Well, I mean, I think, I don't want to say that's unique to Florida, but I think that's less common than more common, that kind of model of a pre-file interview. I'm sure, I think Indiana, Kentucky might have something similar to that, as I recall. I'm sure other jurisdictions, and I probably did a gross mischaracterization of Kentucky and Indiana for all I know. But regardless, even if you have something that's a grand jury model or an arrest and then indictment type model, or even if you have what I'm used to in somewhere like Pennsylvania, a complaint and then a preliminary hearing model. I think there's opportunities to do that by talking to officers. There's opportunities to do that even in Pennsylvania to prelim, when you would meet with that officer, even though there's sort of tight and compressed timelines, figuring out what charges you want to add to the criminal complaint and being able to amend the criminal complaint, which is allowed liberally as long as you have the evidence to back it up if there's any subsequent hearing. But before there's any sort of what I'm going to call a formal arraignment where the defendant's entering a plea of guilty or not guilty, trying to figure out exactly what the case is about. And I think a lot of responding officers, in their mind, a lot of them are understanding this is more than just a simple episode of an assault. There's a bigger context here. There's a bigger story here. And the charging tools to show that context isn't always what's developed in police academy. And I think by working with that police officer, finding out what is this case more than just that response you made to this 911 call? What kind of history or context do we know? Is there going to be maybe cell phones we want to grab? Is there going to be other incidents that should be charged or could be charged either independently or as part of a stalking course of conduct? Have there been other cases that have been dismissed and maybe should be some witness intimidation opportunities, or are going to set up forfeiture by wrongdoing? In the idealized world, we could do this with every domestic violence case. That might not be possible given the volume, but hopefully we get the tools to sort of know when our antenna should go up about which ones we should do this for. And we can feel that out by talking with officers and getting their vibe on it as well.
Mm-hmm. Yeah, I think that's the key, is however you map out how a case works in your jurisdiction to figure out there are these opportunities. So instead of just showing up at a prelim and getting them on the stand, getting the elements out, like make the time to have a fuller conversation at that point, or whatever makes sense. Or, nothing prevents us from calling officers or asking them for more details along the lines. And one of the things that we should always have conversations about is, do we know everything that you know? Because as everyone is aware, our ethical duty to provide discovery and due process along the lines of Brady and Giglio, we are imbued with the knowledge of our fellow prosecution team partners, including law enforcement. So this would be something that particularly before a trial, you want to make sure you go through with your officers.
And there can be a lot of pitfalls because of just like a lot of prosecutors' offices have bureaucracies, which only intimacy can help us understand. The same is true for a lot of police agencies. And there may be police agencies where you talk to the arresting officer or responding officer and ask for discovery. It's like, hey, can I get the discovery in it? And just with the way things are designed, you're only going to get the narrative reports. But you might not get the call logs or the response logs that have important timelines and other information. You might not get the property logs. Well, and from the logic of the police agency, it's like, well, that's a different department. That's property or evidence. This is patrol. Why would we combine the disclosure of the records? My experience is I've dealt with agencies that have had, where I learned through experience to ask for these sorts of things from multiple departments at once. But yeah, it's learning what to ask for is done by building relationships. And understanding that when you ask for everything, that individual officer might not even understand or have an appreciation of their own agency, what you can get. Like if you ask for everything, are you going to get pictures, or do you have to ask some digital forensics folks for the pictures that were developed or taken in a case? Yep. Various things.
Communication on case updates. I often would have officers sort of come to me, especially when I was a supervisor, and they just say, hey, what's going on with that? And or they would just get a notice that that case was dismissed or a case pled out. And I really did feel often that they felt like, oh, I'm not being kept up to date. I don't know what's going on. And maybe it's because we're always trying to make sure the victim is updated. Obviously that's a primary concern. But maybe we aren't as good with the officers, and that's a way to continue to engage with them and to have them feel like we are buying in as equal partners.
And, and I think email, frankly, is a great tool to do that. And yes, I know everyone's inbox gets overloaded, and mine's no exception. And that was something I sort of had to adapt for practice, because when I started in the late 90s, early 2000s, email was more of a novelty than a thing. And it developed into more regular practice. But trying to, one, make sure you're available so the officer can contact you, because maybe if you have volume, it's impossible to update officers on every case and every negotiated resolution. And sometimes you don't know when the officer is going to be concerned and when they're not going to be concerned. But helping to get that spidey sense about which cases an officer ought to be concerned about or may be concerned about, and then keeping them updated through email. But then also, if your spidey sense is malfunctioning or not attuned, making sure your contact information is out there so the officer knows that they can proactively reach out to you to get updated. And if nothing else, it might sort of prompt you or tickle you to, oh, gee, yeah, I better unpack that case. It's been sitting for a bit.
Yeah. Follow-up investigation. This, I think, is really one of the paramount benefits of that open communication and building those relationships, because oftentimes we are going to be asking for, whether it be that 404B evidence, we want to get some history of the relationship, or you've mentioned a few times stalking, and we've got another one in this series that's dedicated to sort of charging decisions, and the other one being proactively looking at witness tampering, which we should be expecting in every single one of these cases.
But yeah, and a lot of times these requests for follow-up investigation, I mean, depending on the nature of your jurisdictions and involved and the scope of your agency and how the police agency is set up, this can be sensitive too. And having an appreciation or understanding of that, and when you have these requests for follow-up investigations, and not just giving a bullet list of talk to this person, do this, do that, but giving the context about why you want that to happen and why this can help develop the case, why it's going to be important for the victim, and talking to the officer and getting contact with that officer. Look, before I send this email about what I need, I can give it to you in writing, but should I forward it to you? Is this something that's going to have to be given to investigations? Is this something, should I copy your supervisor on it? Should I not copy your supervisor on it? What's going to put you in the best position for this to happen? And trying to understand just a little bit about the mechanics of how that police agency might operate. Because yeah, frankly, with the nature and demands of patrol requirements right now, some agencies might be like, look, a patrol guy can't do this, but then have a follow-up plan. Okay, if the patrol guy can't do it, rather than complain about that, how can we get this done? Yep. And pursue it that way.
I always loved asking that when I got shut down. Well, okay, so who can I talk to? What can I do? And then maybe assign an investigator, or within our office, we had some investigators that worked for our office. So it's always trying to ask, because there's always a way, right? There's always a way to get it done.
If you're the squeaky wheel, you can get greased.
Safety planning. And this is really where our, both our systems-based and our community-based advocates shine in the safety planning, whether it be tech or otherwise. But our officers are also key to this piece of it. And I think we can engage with them as well, especially when it comes to that, inevitable witness intimidation that we see that can turn into stalking, that can turn into, us really wanting to build out. And we have another part of this series is going to be dedicated to sort of that forfeiture by wrongdoing piece of it. And so I think officers play a part in that safety plan as well.
I agree absolutely, and we should talk to officers about that. We should also be talking to officers that, hey, look, victims might, they usually have the best sense of their own safety and how to develop that. And we should talk to officers, and many officers do understand this. And I learned this actually from a lot of officers. But for some victims, a police response to offender contact might heighten the danger for the victim. And talking to our victims to appreciate, or talking to our officers about how to appreciate that risk and weigh that risk, and talk to victims about it. So that when there's a contact, like maybe the offender's family is harassing the victim, and it's like, look, we can get an officer there and talk to them. Is that going to make it worse for you? Do you want us to do that? What's best? I'm not saying we put the responsibility for the victim's safety on the victim, but we want to listen to their input and make sure that by our interventions, we aren't making life more difficult for our victim.
That's a really good point. Thanks for sharing that. So another possible intersection, it should probably be a probable intersection, is preparing for trial and having an interview. And I know sometimes this happens in the corridor of the courthouse, but trying to be more intentional about that. And I love what you're saying too, is making yourself available so that they also know that they can reach out to you, because sometimes we do assume, oh, this is, a fairly simple case and you know what you're doing. And then I'd have an officer tell me like they've never actually testified before. And you're like, oh, that is scary. In fact, I was called as a witness in a trial when I was a prosecutor, and I had to go testify in a trial, something I witnessed when I was in law school. And the experience of me being a witness in another courtroom in another jurisdiction just completely changed how I prepped witnesses for trial. I never made an assumption, oh, they've got this or anything like that, but I don't know. I'm sure that I did before that experience.
And I think of the collaboration too with the pretrial interviews, especially with law enforcement. I always think of the issues with third shift folk, and like, hey, look, I have a 9 to 5 predisposition or conception. But like for those third shift folks, like, can I get them contacted quickly at 8 a.m. in the morning when they're in their shift? Can I make time to talk to them at 10 p.m. at night? That was much easier when I was younger, before 10 p.m. seemed so late to me. But trying to recognize when you're trying to connect with officers for these pretrial interviews and connect with them. I mean, ideally, you're going to talk to them in an office, arrange an appointment. They come in, they sit down, and you say, hey, this is my strategy. This is my plan. These are the areas I want to hit with you. Anything I'm missing, anything else I should ask about. Some officers, they might not be able to do that. So that's something, try to accommodate and meet that too. And I think it can go a long way. And that goes the same thing for this next point, trial strategy. It sort of was segueing into that in my head too. Like, when you're thinking of your witness order for officers too, especially if you have multiple officers, one of whom came off third shift, as much as you can, I think you're better off trying to arrange that officer earlier in the day rather than later in the day, because they're going to be a fresher or better witness if possible. Or if they're not going to be called in the afternoon, saying, hey, you don't have to come in until the afternoon, so they can hopefully get a little bit of sleep.
Mm-hmm. I always would ask, so what do you think the defense is going to be? Because I felt like they had that time with the defendant on the scene, however long that was. Maybe they even conducted an interview, which is more than I ever, FaceTime I ever got. So like, they could really tell me little tells, and they were very accurate when they would be like, oh, he's going to testify, or he's not going to testify, or, this is what is going to happen. And they did, depending on how engaged they were with it, sometimes we talk about, like developing a theme or a theory of the case that could be really effective trial presentation strategy. And, those officers, a lot of the officers really loved being engaged to that level. Not everyone, but I always found it being, it enhanced my preparation, it enhanced my strategy going in when I had that sounding board of somebody that really had more on scene sort of interaction with the parties than I ever would.
I always think too, like, even in terms of utilizing that officer, like when I'm examining some witness, like I'd always worry about forgetting something. And I try to involve, especially my investigating officers, this is what my plan is with this witness. This is what my strategy is. And a little thing I'd always do is, and I was in a jurisdiction where the investigating officer sat at the prosecution table with me. Hey, did I forget anything? Anything else you want me to add? And I wouldn't, sometimes I would take their suggestions, other times I wouldn't. But I would always ask for input quick, just to like have that humility, like, gee, maybe there's some angle I neglected or forgot too. And if you're, same thing with jury selection, if you're in a jurisdiction where the police officer sits with you when you select a jury, which I always think is probably one of the worst cops of duties or parts of law enforcement, because you just sit there while the attorneys pick a jury. But if you do have the availability of the law officer, get your input about their panel members. I mean, most officers know the community and your communities in your jurisdiction pretty well, pretty well connected, and might have a sense or vibe of the people involved, and can give you some input or insight. I mean, that's trial strategy. So obviously you as the attorney have the final call, but I think the more informed input you can get for that call, the better.
Yeah. And our last point of possible intersection that I have identified, I'm sure there's more, is the opportunity and really taking the time. And sometimes, trials over and we're moving on to the next thing, but trying to be intentional about maybe doing some form of debrief or case review with our officers and say, okay, what went right here? What did we do here that made us successful? Or maybe what were some gaps here that we didn't anticipate, or, these cases are just incredibly challenging. But if we have that opportunity and take advantage of doing some sort of case review or debrief, I think that can also continue just to build the momentum of that relationship and demonstrating our really genuine desire to be collaborative on a deeper level.
I agree with that. Absolutely. I think another thing you can do is that when you have a successful collaboration with an officer in a case, send a letter to the chief, to the commissioner, about how great this officer did, whether it's a patrol guy, whether it's a detective, like, hey, we did this case together. This officer went above and beyond the call of duty. He's a credit to your agency, credit to your department. Please note this for their permanent file. And I mean, a lot of officers are going to appreciate that, because that's the kind of kudos that serves them well in their job and their profession. And they don't always get a lot of recognition, and giving recognition when it's due can go a long way.
Yeah, absolutely. That's a great way to end this as well, right? To build on that collaboration and to demonstrate it and give them, that positive reinforcement when the collaboration has gone well. And so hopefully, as this conversation demonstrates, there are lots of opportunities to enhance collaboration, no matter sort of what level you are in the office or where you are in your career. Sort of a matter of mapping that out and then enhancing the communication, which then enhances the trust, which then allows us to have these relationships that ultimately are victim-centered and focused on enhancing their safety, autonomy, privacy, and the side benefit maybe being able to enhance their participation and hold the offenders accountable when we do this collaborative approach. So, Jon, I am so happy you are here with us today. Thanks for all your insight. And here's my information. If anyone wants to reach out, I can get you in touch with Jonathan as well, and put a plug in for AEquitas's office hours. I know, Jon, you are often leading these the third Thursday of every month from 2 to 4 p.m. Eastern. Great opportunity to sort of network with your peers, discuss emerging issues. Usually each week or each month, there's like a topic du jour, but we're really hoping to serve as a hub for those of you that are doing this really challenging and important work. So thanks, everyone, and we'll talk to you later. Thanks,
Thank
Jon.
you, Jane.